One other thing. While we were before Judge Kramer on the issues of my son, I was also before him again with my mother trying to get her property back. Filed a motion with him to get it dismissed. He just dismissed the motion, wouldn't really address the issues. We appealed to the appellate court. Now the issues before the appellate court were the family court needs to demonstrate jurisdiction no matter what, because it's a court of limited jurisdiction as defined by the state constitution. My mother was an interested party because she was part owner of the house. James had no jurisdiction over my mother because she was never served with any papers, was not given notice, and as a matter of fact was thrown out of the courtroom. He also didn't have jurisdiction because it was non-marital property which he has no jurisdiction over. Judge James had no authority to award exclusive possession of non-marital property. He can't do marital property. How can he do non-marital property? Lack of jurisdiction can be raised at any time in a proceeding, even after the proceeding. You can go back and get an order overturned if the court had no authority to do so. The case law on that is, on motion, the court which rendered a judgment or order may relieve a party from it upon such terms as may be just, on motion of any interested party. It is black letter law that a judgment rendered without subject matter jurisdiction is void, and that defect may be raised at any time and may not be waived. That was Lax versus Lax. It was a 1976 Court of Appeals ruling. So it's very clear. It can be raised any time. We keep raising it, they keep ignoring it. In this case, they went a step farther. Petitioners now contend that as inasmuch as family court has no jurisdiction to effect a general property distribution incident to a divorce. This wasn't incident to a divorce. We were divorced in 1981. And no jurisdiction over property purchased after the parties divorced and owned entirely or partially by third parties, the Kings. These provisions are null and void and should be vacated pursuant to 5. We disagree. Whereas here, the issue of support has been expressly referred to the family court. There was no referral. And then they go on court. In this case, the reference was contained in the parties' amended separation agreement. It's required, as I previously documented, required to be in the judgment of divorce in a decretal paragraph. Further, they completely ignored Section 251 of the Domestic Relations Law, which states that in the court order referring it, which they claim is referred, it has to be stated that it will be filed, it has to be filed with the family court within 10 days of the judgment of divorce being rendered. It didn't state that. The referral did not comply with the law, but they just make it up. And besides that, parties to an agreement can't confer jurisdiction upon a court. And family court has no authority, as previously documented, over separation agreements. So even if it was in an agreement, you can't agree to give a court jurisdiction that doesn't have it. This is how bad these are. This is how they lie. It looks really good when somebody reads it, but if you don't know the facts, which nobody knows because they don't print the briefs or anything or let you see the briefs. Amended separate, which was incorporated into the divorce decree, that the court is empowered to decide matters related to the possession of property if they are directly pertinent to the issue of support. This was 3 years after the house was purchased. Number two, the other thing too is, it still doesn't comply with the law because I'm being ordered to pay both more than child support than is required under the Child Support Standards Act, plus housing, which included in child support is housing, and to make it even further, the courts are closed. They just dismiss the stuff. They don't want a trial on it or anything. Possession, if directly pertains the issue of support, but it doesn't state the reasons why the court deviated. That is also required by statute. They ignore that. You have to state, the court was required to state what the child support would have been, what they are ordering, and the reasons for the deviation. Has never been done. It's an invalid court order, but they blow it off. You know, this type of stuff has got to, it's got to stop. I mean, these judges are out of absolute control. And again, my buddy Judge Spain is involved in it. White, Peter, Spain, and Gaffio, who's also useless. She was involved in when I was arrested and denied me my rights under the law at that time also. So what did we do? We appealed to the Court of Appeals those issues. Yep, you're right. The Honorable Judge Judith S.K. Upon the court's own motion and the appeals by appellants Collins and King being the same, hereby are dismissed without cause upon the ground that no substantial constitutional question is involved. My mother is being deprived of her property by a judge who lacks both personal jurisdiction and subject matter jurisdiction. Both are required before a court can make a determination. She was never served. A court of statutory jurisdiction, family court, has certain inherent constraint, and before it may act in accordance with due process, must have subject matter jurisdiction as well as personal jurisdiction over the parties. Judge James had neither. Says due process. That is a constitutional right, but not according to Judge K and the corrupt judiciary in this state. I wonder how Judge K or Judge James or Kramer would like it if their homes were taken and given to somebody else. I can tell you, they would be screaming bloody murder. They think it's a joke that children are abused. They think it's a joke. They're going home every night laughing their asses off at all the litigants before them. That's all they want to do, is screw people over because they think they are gods. They are not gods. Look at $23 million for housing. Now, one last thing. Judge Kramer. Every father I've known that was before Judge Kramer hated him. I don't think I've ever run into anybody that said he did a good job for him. He screwed them all. Then one day I'm reading the newspaper, and it was on the news too, and I go, that's it. Now this is my opinion. It talks about how Judge Kramer was a big basketball star when he went to school in, I think, Schenectady, and wherever he went to college, he was a big basketball star and everything. And then it dawns on me. He's in the locker room. He probably discovered he's got the littlest one of all. He's got to show he's superior to everybody. I'm bigger than you. I'm better than you. So because of his inferiority complex, now I'm not a psychologist, don't claim to be one. But again, this is my opinion, and I do believe I'm entitled to my opinion. He has to show he's better than everybody else because he has an inferiority complex, little one. So everybody out there, when you see Judge James or Judge Kramer walking down the street or anything, wave to him, give him the, we know. He shouldn't even be on the bench. He belongs in jail for what he is doing to people. These illegal court, leaving somebody with $5 a week or $10 a week to live on. He comes home with $310. He orders them to take out $301. He spends more than that for lunch. Guy loses his job, loses everything because of what Kramer is doing. This is how he gets his kicks. It's screwing other people. This is how the judiciary operates. Remember, these judges think they're above the law, and they have allowed to be above the law because the corrupt DAs, the corrupt attorney generals of the state of New York, the federal, are all covering up the judges for each other. It's got to stop, and it's got to stop now. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law.